So I have an important update in the current battles against Illinois and their ban on so-called assault weapons. So let's talk about what is happening. Also, I want to thank one of the main supporters of this channel, which is 1st Phorm. 1st Phorm is an amazing company. They have amazing supplements, and they've helped me along my journey as I'm trying to get healthier and work out more and lose some weight. And, it's one of those companies that not only has amazing supplements, but they believe in the culture and ethos that we have here on the channel, which is pro-freedom, free speech, pro-Second Amendment. And so they do a lot of things the right way, and they're a company that you would want to support. Check out 1st Phorm. I will leave a link down below in the details section, the pinned comment, if you want to get amazing supplements, and then also you want to support a company that believes in the Second Amendment. As I mentioned in the intro, in this video, I have some important updates in the current battles to strike down Illinois and their ban on so-called assault weapons. We're going to be talking about multiple cases, that are kind of right now aiming to fast-track Supreme Court review on this issue of rifle bans, and then also lower courts doing the same thing. There are multiple cases that are now asking for the United States Supreme Court to grant review to these Illinois cases, but while all of that is happening, a lower court judge who prior issued a favorable order on this issue has also moved to expedite review in the cases. This has set up an interesting situation where the same cases are now doubling up, seeking Supreme Court review and lower court review. Now, you may recall that recently we received news that the Supreme Court denied 2 emergency injunctions, which were asking the Supreme Court itself to put a temporary halt on a statewide rifle and magazine ban. Those cases were Colkins v. Pritzker and then also NAGR versus Naperville. These cases involved a challenge to the Protect Illinois Communities Act, or PICA, which places unconstitutional restrictions on rifles and magazines. PICA also requires a registration requirement to grandfather in those already possessed rifles. In Colkins, the case was originally brought in an Illinois state lower court, who on review entered summary judgment against the state of Illinois, declaring that the ban was unconstitutional for denying equal protection under the law. In response to losing that case, the state of Illinois appealed the decision up to the Illinois State Supreme Court. So that went to a state Supreme Court. And on review, that Illinois State Supreme Court reversed the lower court's decision. In that case, there are specific concerns also about some of the contributions of 2 of those judges who sit on the Illinois State Supreme Court. So there are a lot of questions about that and, them receiving millions of dollars worth of donations from some of the defendants during their campaigns. So a lot of question marks about that. After they lost at the state court, Supreme Court level, they filed for a writ of cert to the U.S. Supreme Court. And then they also filed an emergency application for a stay, which also went to the United States Supreme Court and went to Justice Barrett, who's responsible for those types of emergency applications that come out of the 7th Circuit. However, the Supreme Court denied both the request for the emergency stay, and then later, after holding conference in the case, also denied ultimate review of the case. So that was kind of the first loss. And then there was a second case that denied emergency request in the Supreme Court, and that was the NAGR versus Naperville case. In the NAGR case, the plaintiffs also filed for an emergency intervention. They wanted the Supreme Court to step in early, put in place an emergency stay. That was something that was going on in the 7th Circuit en banc panel level. And then the case also kind of tried to jump the line and go to the U.S. Supreme Court in the interim. But ultimately, the Supreme Court denied that type of emergency stay. They denied it at the Supreme Court level. And then ultimately, what interestingly also happened is the 7th Circuit en banc panel denied review in the case. The Supreme Court's denial of emergency relief and the 7th Circuit's unwillingness to review this issue set the stage for multiple cases to now splinter off and attack the law on 2 different fronts. Now, multiple cases in Illinois have filed traditional writs for Supreme Court review, and briefing is taking place at that level in those cases. At the same time, the lower court and Judge McGlynn have decided to move these cases along for a decision on the merits. Judge McGlynn recently held a conference on multiple PICA cases, and ultimately he said that they need to move forward. These cases were the Langley case, the Barnett case, the FFL case, and then a bunch of other ones as well. During a hearing in front of Judge McGlynn, he represented that he intends to move these cases along as fast as possible to an actual merits decision. There were multiple parties, including some of the plaintiffs and also the state of Illinois, who were asking for Judge McGlynn to delay the lower court's case, delay the review in these cases because of the Supreme Court certs. But Judge McGlynn told all the parties that he does not intend to delay these cases any further. He wants to move them forward. He told them during the conference that the only time he might delay these cases is if ultimately the Supreme Court grants review in one of these cases that is currently pending for Supreme Court review. But that's the only time he will actually hold a delay in any of these lower court cases. And then recently we received an order from Judge McGlynn outlining this issue and the facts that he's trying to develop at the lower court level so that he can issue a ruling on the merits. Judge McGlynn stated in his order that The factual questions the court will address include: 1. Is the item an arm as defined in Heller and Bruin? 2. Is the item an arm as defined in Bevis? 3. Is there a rational basis for a civilian to select a particular arm for use in self-defense in the home? 4. Is there a rational basis for a civilian to select a particular item for use in self-defense outside the home? 5. Is there a rational basis for a civilian to select a particular item for use in self-defense to repel a riot or large-scale attack? 6. Is the item an arm that may be used to resist tyranny? 7. Is the item exclusively or predominantly useful in military or law enforcement settings? 8. Is the item specifically designated by the United States military as a weapon to be acquired by the United States military and issued to its troops? 9. Does the item meet all the specifications required by the United States military to qualify for issue as a rifle or pistol to be deployed with United States troops? 10. Is the weapon materially different from an M16, M4, or a machine gun? 11. Is the firing rate of a semi-automatic weapons banned by PICA materially different from the firing rate of the M16, M4, or fully automatic machine guns? 12. Is the item a dual-use arm that may be used in both military and civilian settings? Is the item principally possessed and used for unlawful purposes? 14. Is the item in common use? And 15. Is the item dangerous and unusual? Now, in this order, he also goes on to state that if the plaintiffs establish that the weapons, attachments, or ammunition feeding devices prescribed by PICA are arms included within the protective reach of the Second Amendment in line with the Friedman and Bevis, the government must affirmatively prove that PICA is part of the historical tradition that delimits the outer bounds of the right to keep and bear arms via a showing of how and why the regulations burden a law-abiding citizen's right to armed self-defense. The court notes that such raw data has already been provided in other Second Amendment challenges across the United States. And there, on that last point in that last sentence, they cite to Judge Benitez's decision and his analysis in the Rody v. Bonta California ammunition restriction case that we recently got in California. Essentially, what Judge McGlynn just did in his order is he paints a very clear picture and almost gives a step-by-step guide to all the parties about how he wants this case to proceed forward and what he wants to see in their briefs. And really, this is a strict guideline, which is probably in our favor and, favors the Pro 2A side and not the state of Illinois. Prior, Judge McGlynn has ruled in our favor, striking down some of the PICA language. And now with a merits review that he's moving forward with, he's telling Illinois very clearly that they must show these items are not arms, like they contest they're not. And if they are arms, well, then they need to justify how PICA is historically consistent with the Second Amendment. What this means is that looking forward, if you're in Illinois, there are going to be expedited reviews in all these cases in front of Judge McGlynn at the lower court level. He's trying to get this stuff done as quick as possible. He's trying to force the Seventh Circuit to ultimately have to review these cases, at least on merits reviews. So he's trying to get this resolved at the lower court level, constraining what he's going to be reviewing, being very clear about what he's going to be reviewing, setting the parties to provide this types of factual information that the Seventh Circuit says it needs to rule on the merits of this case. And so he's trying to proceed forward as fast as possible and get all the factual information that he needs. Now, also looking forward, we'll be watching multiple PICA cases seeking Supreme Court review, like I said. But in my mind, those again have kind of a long shot. They're at an interlocutory posture. They're not on final merits review. So it's going to be harder to get the Supreme Court to review those. And the Supreme Court has denied review in multiple cases already coming out of Illinois. So I'm not sure that's going to happen. But there is one case that, in my opinion, has a better shot. And that's the Bianchi v. Frosch or the Bianchi v. Brown case that's out of Maryland. And that deals with Maryland's rifle ban. That case is up on a writ before judgment. And in some ways has a good shot because prior to that case, was GVR'd by the Supreme Court. It was GVR'd at the Supreme Court, issued their Bruin decision. It went back to the Fourth Circuit. The Fourth Circuit 3-judge panel had an opportunity to rule in that case, but there was no ruling on the case for 13 months after oral argument. And then suddenly the Fourth Circuit en banc panel decided that they wanted to play some shenanigans. They wanted to avoid any positive ruling. So they took the case, didn't let the 3-judge panel issue a decision, and then now it's in their hands. So that is kind of a clear defiance issue, which is now in front of the Supreme Court. And Bianchi is asking not just for a review of a rifle ban, but also this defiance that is now playing out in a post-Bruin world. So as things develop, if we get any more information, I will let you guys know. Also, if you like this video and you'd like to support the channel, one of the best ways to do that is to like, comment, and subscribe. All those things help to fuel the algorithm and it signals to YouTube that you guys see value in these videos and in this type of two-way news. But as always, thank you all for watching. Don't forget to like and subscribe. And never forget, this nation was built by armed scholars, and this nation will be maintained by armed scholars.